Okay, everyone. Well, welcome back. I'm David Weber. I'm the Associate Dean for Intellectual Life here at Boston University School of Law. I'm also a professor here, and I'm delighted to welcome everyone back to the second panel of our conference, Marijuana Law 2020, Lessons from the Past, Ideas for the Future. So panel number two is on the continuing effects of federal illegality, taxation, banking, and more. And we have a terrific panel here. We're going to change up the order a little bit from what's on your agenda, but let me introduce our panelists and before turning it over to them. So first, we're going to hear from Julie A. Hill, who is the Alton C. and Cecile Cunningham Craig Professor of Law at the University of Alabama, and she's going to be speaking on the topic of banking hemp. We're then going to hear from Benjamin Leff, Professor of Law at American University Washington College of Law, on cannabis taxation theory and practice. We will then hear from Lauren A. Newell, who is the Associate Dean for Academic Affairs and Professor of Law at Ohio Northern University Pettit College of Law, on the subject Hitting the Tripwire: When does a business become a marijuana business? And then finally, Sam Kamen, the Vicente Cederberg Professor of Marijuana Law and Policy at the University of Denver, is going to be offering some comments on the three presentations. And after Sam's done commenting, we will open it up for some additional discussion and for some Q&A. So for right now, I'm happy to introduce Julie Hill. Take it away, Julie. Julie, I don't actually hear you.
Oops. Good night. You'd think I'd have that figured out after a whole semester of class via Zoom. So what I'd like to talk about today is the difference between what marijuana banking can learn from our experience with hemp. So if we can make all of this work here. Okay. So in June of this year, the Financial Crimes Enforcement Network, the folks who collect information on marijuana banking, said that there were 510 banks and 185 credit unions that were actively banking marijuana businesses. As you can see, this represents only a small portion of the number of financial institutions in the United States. And it's not exactly news that marijuana businesses have banking problems. And folks have been saying that for quite a long time. And actually, I think if you look at the problem over time, it's changed somewhat. I think in the beginning, it was just very, very difficult for marijuana businesses to even have a bank account. Most marijuana related businesses are able to get at least some banking services, but they still have marijuana banking problems. So what practically does that look like these days? Well, because there are so few financial institutions in this space, it makes it hard for businesses to find a bank in their area that can provide services and then also to keep their financial institution. Sometimes a bank will get into this space and figure out that they're not making money off it, or it's more difficult, or that their regulators aren't as excited about it as they thought they might be. And so they change their mind. And so this means that sometimes businesses have to jump from bank to bank as the landscape changes. When businesses do end up getting just a basic checking account, they can pay thousands of dollars a month just for the privilege of being able to deposit their money and write a few checks. So, as we know, that's not what most business bank accounts look like. And so it's very expensive. And that's a problem for people who work in this space. All of the major credit card processing networks in the United States have said that they do not intend to allow credit card payments on their systems until marijuana is legal, fully legal at the federal level. And so that means that there's no accepting credit cards if you're a marijuana business. Now, there are some businesses that try to get around this by disguising the nature of the payments, but I think that all of the credit card processors are pretty clear on this, that they don't want marijuana payments on their networks until there's a change in federal law. It also means that even when they get banking services, they don't get the full range of banking services. So it's still very difficult for marijuana businesses to get a loan from a bank. And because banks provide most of the funding for small businesses, that means that there are few financing options for marijuana related businesses. And even though marijuana businesses have started to come into the banking system, that doesn't necessarily mean that it's easy for marijuana businesses that might have a stockpile of cash because they've been in business for many years to just take that cash and deposit it in their new bank account. This is that some marijuana related businesses still have stockpiles of legacy cash that they weren't able to get into the system in past years that they're not sure what to do with. And because of the historic problems with marijuana banking and this legacy cash issue, lots of thieves still view marijuana related businesses as places where they can find a lot of cash, and that still makes them targets for um, crime, crime and criminals, and that's not good either. Uh, so, why don't banks offer services to marijuana businesses? Well, if you ask the credit card processors, they say it's because marijuana is illegal at a federal level. And if you ask any of the major banks, Wells Fargo, Bank of America, those sorts of banks, they all say the same thing. Other banks might not want to be in this space because the compliance burden is relatively high. uh, when a bank accepts money from a marijuana related business, the Financial Crimes Enforcement Network wants them to file suspicious activity reports that describe the nature of the business and identify whether or not the business is implicating any of the federal law enforcement priorities. And this compliance burden is part of what drives the cost of the accounts that banks provide to marijuana related businesses. And then finally, every bank has their own reasons for what they do. And so some banks might not be in this space because marijuana isn't legal in their state yet, or they might just view it as too risky, or they might not think that there's a big market for cannabis banking, or they might just be morally opposed to cannabis banking. So there are many other reasons, I think, besides just the legality and the compliance burden that might lead banks to make decisions. Also, banks have their own business plans, and so cannabis just might not be in the business plan because they focus on airplane financing. So I think that we'd never expect to see 100% of banks in this space, and there always, for some reason, would be banks that would choose not to bank marijuana businesses. Um, so there are a number of proposals for changes in legislation that might help the marijuana banking problem. And I know that our last panel just spent a lot of time talking about some of the federal legislation that would decriminalize uh, marijuana at the federal level. And so I'm not going to spend a lot of time talking about the ins and outs because they've done a much better job than I decriminalization at the federal level. There is the SAFE Act, which is designed just to fix the marijuana banking problem. And so it says that federal banking regulators shouldn't be able to take any adverse um, action against a bank that engages in marijuana banking. And it would require updated uh, guidance on suspicious activity reports that might reduce the compliance burden for banks that are in this space. Uh, Now, I think it's a little hard to know whether any of these acts would actually solve the marijuana banking problem. And the reason that I think that is because I think some folks think that decriminalization is like magic, and that if you decriminalize marijuana, everyone would bank marijuana businesses. Everyone would be in this space and it would be easy and cheap for marijuana businesses to find banking. But I think the experience with decriminalization of hemp shows us that that's not likely to be the case. So in the 2018 Farm Bill, at the federal level, hemp was decriminalized. Hemp is now excluded from the definition of marijuana in the Controlled Substances Act, and the act further defines hemp as cannabis plants that contain less than 3.3% THC. Now, the idea is that what's supposed to happen is states and the US Department of Agriculture are supposed to come up with permitting systems that allow folks to apply for permits to grow or process hemp, and that once you have a permit, you're allowed to do that, and there are no criminal consequences. So, you think that maybe, certainly some hemp producers thought that this would make it so that all of their banking problems went away and that they could have cheap banking relationships and that they could borrow money. And this is not at all what happened. Um, no, at least initially, folks said, well, it's just because we don't have all the legislation in place yet. Like once we get all of the rules about how you get a permit, and once we have all of the rules about banking, once the banking regulators have acknowledged that this change in the law, that it'll be easy. But even now that we have that, there's evidence that it's hard for hemp producers to get banking relationships. The best evidence of this, I think, is a Wisconsin survey from December 2019. Ask banks in Wisconsin, are you currently accepting deposits from hemp businesses? And 62% of the banks said no. Are you currently lending? And almost no banks were. Now, there's some reason to be optimistic because I asked folks if they might lend in the future or accept deposits in the future, and those percentages were a little bit higher. But still, I think there's a good number of banks that don't want to be in this space. And the question is, why not? And the answer could no longer be because it's illegal, right? The answer has to be either because of the compliance burden or for some other reason. And I think there's reason to suspect that the compliance burden is still pretty high for banks. So in order to operate as a hemp producer or processor, you have to have a license. And banks, before that they can serve these customers, have to be able to tell that they have a license. But that's not always easy for banks. In some states, they've come up with systems where they just put the list of people who have licenses, their names, address, contact information. It's all online. The bank clicks on there. They know who has a license. They can confirm their customer has a license. In other states, they've been very concerned about the privacy of these folks who have licenses. And so it's much harder for banks to figure out if folks have a license. For example, in Kansas, they have a list of the names of people who have licenses, but they don't have any contact information. And if you want to get that contact information, you have to file an open records request, and then you have to fill out a confidentiality agreement that you're not going to share the information with anyone else. And this makes it harder and more costly for banks to serve these customers. Another problem is that all of the permits, if you're going to be a hemp grower, have to describe land on which hemp is going to be grown. And in South Carolina, earlier this year, a hemp farmer was actually arrested because he'd originally got a permit to grow hemp on 20 acres, but he decided that 10 of his acres didn't have enough water. And so he switched those 10 acres to a different 10 acres. South Carolina found out about it, came, arrested him, and bulldozed 10 acres of his. Just have who has a license, but what property is licensed, and they need to be checking lists. Increases the risk, and if banks don't have access to that information, it can be hard for them to confirm that that's that their customer is in compliance with the law. Same with the crop itself. Does the bank need to be there when they're testing? Do they need to have access to the testing that shows the THC content in the plants? Is the state going to provide the bank access? If they get it directly from the customer, is that good enough? Or does the bank need to confirm it from third party? All of this increases the compliance cost. Now, there are things banks can do. They can have policies about hemp banking. They can have processes that they use to onboard these folks. They can get representation and warranties from their customers that they're not going to violate the law. But all of this suggests there's a pretty high compliance burden, and that states, in the way that they implement their licensing schemes, can make it either easier or a lot harder for banks to confirm that businesses are operating in compliance with the law. So even if the compliance burden was relatively low, though, I think that we'd still see some banks that are hesitant to engage in a full range of banking opportunities. And we can see this with hemp. Now, currently, there are still some questions about uncertainty if a bank, for example, takes a hemp crop as collateral for a loan. Could they repossess it? Can they hold it if they're not a license holder? So there's still some issues to be worked out on that front. But I think even bigger are just concerns about the uncertainty of the hemp market. What is the demand for it? What is it going to cost to actually produce hemp? In the beginning, they said you could grow hemp on any land, it didn't matter. And now they're saying you actually need pretty good soil, high rainfall, and good growing season, which kind of makes sense. That's how most crops are. Um, what's this deal with the THC limit? If you're over and the crop gets bulldozed or burned, that's not good from a bank's perspective. So if there's no way to confirm that on the front end, it seems very risky for banks. And then finally, you've got uncertain supply and competition. If you make this legal and everyone can do it now, does that mean the cost for this goes way down? And for all these reasons, I think banks are unlikely to hop in to underwriting hemp loans in large quantities relatively quickly. So what have we learned? I think we've learned that legalization does not mean that all banking problems are solved. That regulatory uncertainty hampers banking, but even regulatory certainty might not be sufficient to have banking in large quantities, because regulatory structure also impacts banks' compliance burden and how much folks will pay for banking services. Even with an ideal regulatory structure, though, we might expect that there'd be limited bank lending because of credit, market, and other risks that banks just don't know about when you have a product that's been illegal for so long and hasn't had the benefit of us seeing how it works in a free, robust market. That's all I've got. I'll let other folks enlighten us more.
Well, that was fascinating, Julie. I have so many questions. Thank you so much. It was really, really interesting. Let me just tell the audience, by the way, also that if you have questions, we're going to hold them for the end for a Q&A session at the end. But if you do have questions for any of our panelists, please just write them right in the Q&A box that you should see at the bottom center of your screen. You could input your questions there, and I'll field them for the panel towards the end of today's discussion. But next up, we're going to hear from Benjamin Leff. Benjamin.
Thank you. Thank you very much. Let me just apologize for, I think I'm the first speaker not to have any slides or visuals. So you will be looking at my face for the next 20 minutes, and I apologize in advance for that. Hold on, let me just. Okay. So I'm I believe the only panelist in the entire conference who's going to talk about taxation. And so I'm actually not only focused on federal issues, federal state issues, but I'm giving a general introduction to theory of taxation of cannabis. And first let me introduce myself. So my name is Benjamin Leff. I teach at American University's law school, and my fields are taxation and law of nonprofit organizations. My work previously about cannabis taxation actually is about nonprofit law. So I have two articles that are from a while ago now that are about nonprofit law. Here I'm talking about just the design of cannabis taxing regimes. And my talk was inspired by way back in 2014, there was about a 4-minute clip in the podcast Planet Money, which I don't know if anyone listens to Planet Money. It's one of my favorite podcasts, and they talked about the fun, wonky question of how to design a marijuana tax. And they said at the end of this episode, you will be able to design a tax on marijuana, which I think is the most ludicrously untrue and overstatement I've literally ever heard in a podcast. The issues related to designing an optimal or effective tax on the sale of marijuana at the state level, at the federal level, we could be talking about them all day. I have much more modest goals. I'm just making 2 points, one about state level and one about federal level. And they're points that are relatively agnostic about all facts. So that should hopefully produce possibility to have a discussion and response to questions. I have one kind of citation. If you're interested in marijuana taxation, my sort of favorite person out there is Pat Oglesby, who's at the Center for New Revenue, who's written very extensively on designing marijuana taxation, mainly at the state level, but not exclusively. He's great. Okay, so what are my two big points? Okay, first one is state level taxation, and I'm gonna go all the way back to the most basic theory of taxation at all, and just take it right out of classical economics, which is kind of the basic lingua franca of tax policy. So what's our theory of taxation in general? Well, generally in classical economics, we think of if you add a tax to something and thereby raise the price, you disincentivize acquiring that thing or engaging in that behavior. And generally, our theory of taxation is, well, that is generally bad. Again, in classical economics, we presume that kind of the things that people choose to do in the market, they're doing those because if they're doing them freely and it's an efficient market, they're doing those because they believe that they enhance their overall utility. So if you raise the price of those things, then you drive some people out of that market, people who otherwise would be in that market, you're decreasing overall social utility. That's the theory, again, kind of at the margin, those people who are maybe in the transaction, maybe out, you raise the price and you drive them out. Why do we do it then? Well, we do it in order to fund government, and to the degree to which what government does is it takes that revenue and spends it in a utility enhancing, social utility enhancing way, then that trade-off may be worthwhile. And there's lots and lots of opportunities for government to enhance overall social utility by spending money for public goods, et cetera, whatever they are, right? Okay, so already built in, we have this idea that taxing something decreases demand for that thing, which is generally bad. Does it to the degree to which the revenue is used for something that's overall good, then that's justified. But our goal, our kind of tax policy goal always is to minimize the distortion and maximize the revenue. How can we get as much revenue as possible and spend it on something good? That's what other people do. With minimizing the amount that we're driving people out of the market. Basic theory. Okay, but there's this magical kind of tax that in tax policy world we call a Pigouvian tax. It's like, sin taxes are a category of Pigouvian tax. Sometimes they're called regulatory taxes. Here's this magical world where there's a transaction out there in the world that usually we say because of externalities, but kind of doesn't matter why this transaction doesn't maximize social utility. And so by driving people away from it, we're actually correcting an inefficiency in the market. That's a good thing. And then we get the revenue, that's another good thing. So it's a win-win. So like for a tax policy person, a Pigouvian tax is like the biggest fantasy there is in the world. So that's all my kind of, out of the, first microeconomics 101, setting up the theoretical framework. When people think about marijuana taxation, often tax policy folks think of marijuana taxation as a Pigouvian tax. And they think of marijuana taxation as a Pigouvian tax because of concerns about the health effects, the public health effects of increased consumption of marijuana. And so they think about it. We also have taxes, excise taxes on alcohol that people think of as functioning like a Pigouvian tax in a lot of cases, tobacco, gasoline, etc. Okay, so here's my big claim. That is not even for factual reasons, even theoretically, that's like 95% wrong to begin with. And why is it 95% wrong to think of marijuana taxation as a Pigouvian tax? It's because of the last piece of just the basic theoretical model, which I haven't mentioned, which is when you disincentivize one transaction, almost by definition, you move people from that transaction into the second best substitute transaction for whatever reason. So when you increase the cost, the marginal cost of something, then you drive people away from that thing into the next best thing. And so in order to know whether a tax is Pigouvian, that is, are you driving people from something that has some social harms to something else, you need to know not just what are the social harms in the thing, but what are the social harms included in the next best thing. So a really nice example of this is, you know, if you drive people away from using coal, what do they substitute for the use of coal? Do they substitute decreased consumption of energy, or do they substitute increased consumption of natural gas or something else? And what are the harms in natural gas as compared to coal? So really common exercise in you know, environmental studies. So what's the biggest substitute for marijuana? For legal marijuana, well, for the vast majority of the market, the easiest substitute for legal marijuana, of course, is the illegal marijuana market, which is huge and has many, many users who have been using the illegal market very comfortably for years and years and years. So the goal of any tax component of a legalization move has to be for the taxes not to prevent problems for the rest of the system to enable to move the illegal market into the legal market. Now, I really want to emphasize, again, tax policy people don't always emphasize this, but it's really important to emphasize it. Taxes are only a tiny component of the factors that are going to determine what market functions and what market doesn't function. And in the previous panel, we were already kind of introduced to this idea that a lot of whether you successfully move the illegal market into the legal market has to do with how you continue to enforce in the illegal market and what is the nature of the illegal market and what are the various components of the legalization regime. But tax is one of those components. And when you're creating a tax, the most important thing you can do is create a tax that doesn't prevent that movement from the illegal market to the legal market. Now, great news, legalization should produce a tremendous amount of surplus value because illegal, all of the costs of the illegal market, all of the harms caused by the illegal market have costs associated with them. Removing those and moving into a legal market should produce this very, very steep price drop that Professor Calkins in the previous panel had a slide and talked about at great length. So if legalization is creating this huge amount of surplus, then the tax question we want to know is how much of that surplus should be captured by the government. So surplus is being created by legalization. Really, the surplus is largely being created by moves in enforcement, not having to enforce against all producers. So there's this huge surplus. That surplus is available for consumers in the form of lower prices. It's available for the producers in the form of higher profits. And it's available for the government in the form of stepping in and taxing it in order to absorb some of that surplus. And our general model of tax policy, which is, remember, as long as we have good things to do with the money, then we want to maximize the revenue to the degree to which we avoid pushing people at the margin out of the good transaction, which is purchasing cannabis in the legal market, into the less good transaction, that is purchasing cannabis in the illegal market. Did I say that right? Legal market to illegal market, right? That's our general view. Now, if the price drops so low, then maybe we need at the bottom of a price drop to think of it as a Pigouvian tax again, to think, oh, maybe we're letting the price get so low that we're actually creating some social harms that by letting all of the surplus be absorbed by consumers or split between consumers and producers, maybe way down there, we need to think of it as a Pigouvian tax. But that's when the price drops way, way, way down. And remember, our basic model of maximizing revenue would have us wanting to keep the price at a level that maximizes revenue consistent with not driving too many people into the legal market. So the correct framework of thinking about how to tax is, in effect, how do we identify the right amount of that surplus for the government to take, the legalization surplus for the government to take and hopefully spend on good things. And in the case of an industry like marijuana, which, as previous panelists have pointed out, the illegalization has been so associated with particular types of very brutal social harms. One of the best things the government should be doing with that money should be mitigating or repairing or paying reparations for those harms. But whatever the government's doing that's good, it should be maximizing, this is maybe more controversial than I meant to say, maximizing the amount of revenue it can make within that slice of the surplus it's created. All right, that's my state level thing. So what's the federal level thing? The federal level thing, you know, as just very briefly, I'll just say at the federal level under current law, marijuana businesses are taxed under this thing called Section 280E, this notorious provision 280E. It's a very unusual kind of tax. It's a component of the income tax that denies deductions to cannabis marijuana businesses, except for the cost of goods sold. So all of the normal deductions that every business gets to make, cannabis businesses can't make those deductions except for the cost of goods sold, the cost of the product itself. So for people who are tax policy people, that's just infuriating because it's a fundamental attack on the nature of an income tax. An income tax taxes profits. Here's a provision. It's stuck in the income tax. And instead of taxing profits, now it's taxing something closer to gross revenue, something between gross revenue and profits. And that just doesn't make sense as an income tax. It kind of offends good income tax thinking. And there's a lot of hype about 280E being a tax that could drive cannabis businesses out of business or that's just too high. But there's nothing inherent about the structure of 280E that either makes it too high or that is incompatible with a cannabis business, because any tax constructed on income, however you construct it, the solution from the business's point of view is to raise prices high enough so they can make a profit consistent with paying the tax. That's true whatever kind of tax there is. And the constraint on higher prices is a competition, but as long as it applies to all of the players in the market, that's okay, except the illegal market, right? So the constraint on the ability of cannabis businesses to raise money to respond to either state level taxes or Section 280E is this limit that we don't want the tax regime to drive consumers back into the illegal market. But that's not particular to 280E. In other words, any federal taxing regime, depending on how high the taxes are, is going to hit this limit. And so the number one policy question at the federal level with respect to cannabis taxation, it has nothing to do with 280E specifically. It has to do with the fact that if government, broadly, state and federal level, are trying to take as big a slice of the surplus that's created by legalization as they can, they will crowd each other out. So any federal tax will reduce the state's ability to introduce a tax because there's the price limit where businesses can't raise their prices so high that we're driving things back into the illegal market. So the federal government and the state governments have to split this government slice of the surplus. And there's a question, what's the right split? How much should the federal government get and how much should the state governments get? That's a complicated question. The general word for how in tax policy we resolve these questions is fiscal federalism. I'm not going to say a single thing about fiscal federalism. Instead, I'll just point to the fact that that's the location of where we would figure out the proper split. The proper split is the right question, and therefore the question of what's the optimal design of a federal tax is, what's the design of a federal tax that would enable the government to set the rates in a way that coordinates with state taxation to not break this kind of tax rate maximum. And that's the key driving question in federal tax policy. An excise tax would do a better job of doing that probably because states have excise taxes, but there are arguments in favor of 280E as well. They're rarely made, but they are out there. What 280E does in effect is it puts a thumb on the scale against businesses that spend a lot of money on things other than the cost of their product. So what are those things? The biggest things that retail businesses spend money on other than the cost of their product are advertising. So if you have a thumb on the scale against spending money for advertising, the argument could be made that you're favoring small businesses over large brand builders, which is sort of advertising is used to build these major brands. You could argue it the other way as well, but that's the argument. Salaries is the second one. Hard to come up with the argument about why you would be better off with lower salary prices for cannabis businesses. And then the third one is rent. And, built into the tax code, we have lots of provisions that try to drive businesses into low income neighborhoods. Those are also low rent neighborhoods. The idea that we would have this provision 280E that accidentally does exactly that, it in effect drives cannabis businesses into neighborhoods that are low income neighborhoods, is meeting a major expensive tax policy goals of other tax provisions already. So you could imagine making that argument and variations of that argument. The last thing I'll say is the other thing it does is it encourages vertical integration. So to the degree which there are arguments in favor of retail sellers also being producers, 280E does that, and it encourages cannabis businesses to also be doing something else, to have two businesses going simultaneously in the same place. To the degree to which that is good policy, it kind of does that as well. I'll leave things there, and thank you.
Thank you, Benjamin. I think that was fascinating, and I hope we're gonna have to find a way to get you back onto Planet Money to correct their ways, their errant ways. So very interesting and enlightening presentation. Thank you. So next up, we will hear from Lauren Newell.
Hi, everybody. First, I'm going to make the mistake of using the word tax a couple of times in my presentation, so I'm very sorry to be following Benjamin. So please don't tell everyone how I've gotten it wrong, Benjamin. All right, let's see if I can get this going. Okay, we all see what I'm seeing? Okay, today I'm going to be talking about hitting the tripwire. When does a business become a marijuana business? And I'm going to also give the caveat, a lot of this is very fresh. This research is very fresh. So if you have information and sources and knowledge that I should know, feel free. I would love to have your feedback on this. All right, let's get going. So there are a lot of scary consequences that businesses and entities and people involved in the marijuana industry can face. And you see a whole sampling of them on the slide here. But today I'm not going to talk about the consequences. Today I'm going to focus on when do these consequences attach. So in other words, when does a business become a marijuana business that's subject to all of these scary possibilities? What's that tripwire that we don't want to hit? And to go through this, I'm going to be walking you through a number of different scenarios that we can take a look at and see when we get there and when we don't. But first, what is a marijuana business? So the way I'm using it today, a marijuana business is an entity that participates or contributes or assists directly or indirectly in the retail or medical marijuana industry to an extent that exposes its and its owners and its agents to these potential negative business consequences and criminal and civil liability. So in short, these are the companies that should be worried about the fact that they are doing something that's illegal under federal law. Okay. I'm going to start with some of the easy cases, and then we'll get to some of the trickier cases as we go along. So here's our first one, easy case. We've got Brad's Buds. Brad's has a retail marijuana cultivation facility license from the city of Denver, and it goes out and it cultivates and prepares marijuana, and it sells it to dispensaries. Under Section 841A1 of the Controlled Substances Act, it's unlawful to manufacture a controlled substance like marijuana. Clearly, Brad's Buds is going to be one of these marijuana businesses. Our next one, we've got Entire Foods Market, a national grocery chain. It's got $15 billion in annual revenue, and it starts selling some cannabis brownies in its California stores. It makes $50,000 a year annually from these brownies, so they must be pretty good brownies. All right. We saw under 841A1, it's also unlawful to distribute or dispense a controlled substance. There's not some safe harbor for a de minimis amount, so it doesn't matter that Entire Foods, the vast majority of its business is legal and only this small sliver is unlawful. The fact that it's distributing and dispensing means it's bad. It's clearly a marijuana business. All right, still pretty easy. Our third one, we've got Wonderful Warehouses, that it's an owner of warehouse space that leases warehouses to tenants, a variety of different tenants, and it gets 25% of its revenues from leasing warehouse space to tenants engaged in the business of growing marijuana with full knowledge that they are in fact growing marijuana. Under section 856A2, it's unlawful to own and rent knowingly and intentionally space to somebody for the purpose of unlawfully manufacturing a controlled substance. All right, so wonderful is clearly here, knowingly and intentionally renting space to people for the purpose of growing marijuana. Again, pretty clear case, we've got another marijuana business violating an express provision of the Controlled Substances Act. Let's start getting a little bit trickier. Galaxy Brands is a Fortune 500 company. It gets an 8% equity interest in Mary Jane Syrups, a Vermont company that's selling some cannabis-infused maple syrup in its Vermont stores. Galaxy is a passive investor. It doesn't have any right to appoint any members of Mary Jane's management. Okay. So here we have section 854A, and sorry it's so long and wordy, but basically it says it's unlawful to use drug money to invest in or operate a business. So if you get any income from the violation of the Controlled Substances Act, you can't use that directly or indirectly to acquire an interest in or establish an operation that engages in or affects interstate commerce. Okay. To analyze this one, we need to take a very quick detour to a recent case that came out of the District of Colorado Bankruptcy Court. It came out in March of this year in Ray Malol. And so here we had a debtor had a 30% interest in a Colorado medical marijuana business. The business was called Heartland, and it purchased this interest through a subscription agreement. And the court in Malol said it was illegal either directly under section 854 or indirectly as a matter of conspiracy under section 846 or aiding and abetting under section 2 title 18 of the US Code to do all of the following things: to form Heartland, to solicit investment in Heartland, to sell securities in Heartland. So far, not too surprising. This comes straight out of the text of 854. But we go on. It was also illegal for the debtor to execute the subscription agreement. The moment of execution, the court said, is when the illegality came about. It was illegal to own the interest in Heartland, and it would have been illegal to accept any distributions from Heartland. So this is a super broad and expansive reading of section 854. On its face, I think 854 says you can't use drug money to start a business or funnel it into a business and launder money that way. But the court here was reading it in a way that said you can't invest in a business, even using non-drug money to invest in a marijuana business. And if you do, that's illegal. And it's pretty scary that this was a bankruptcy court going so far to find illegality there. All right, so with that background, let's go back to Galaxy and its 8% equity interest. Okay, with the Malol court in mind, I think even though this is a passive investment that doesn't involve control, I think this is going to make Galaxy a marijuana business also. Right? It's a violation of the CSA for Mary Jane's to set up this cannabis business or the cannabis-infused maple syrup, as delicious as it might be on pancakes, still illegal, probably still illegal for Galaxy to invest in that one. Okay. Before we do the next one, I want to hit aiding and abetting a little bit more squarely on, since I mentioned it a couple of times. Right. Under section 2A of title 18 of the US Code, whoever aids, abets, counsels, commands, induces or procures the commission of a crime is punishable as a principal. And liability comes when somebody takes an affirmative act in furtherance of the offense, the underlying crime, with the intent of facilitating the offense's commission. Right. The Supreme Court hasn't been really crystal clear about what the intent that we need is. So some cases, like this case I have up on the slide, the Nye versus Nissen case, says that the defendant needs some sort of personal, meaningful participation in the venture, trying to make it come about. But there are also Supreme Court cases that suggest mere knowledge is going to be enough for aiding and abetting. Very unhelpfully, in 2014, the Supreme Court in Rosemont posed this hypothetical and said, if we have a gun store owner who sells a gun to a criminal, knowing the criminal is probably going to use it for a crime, but just doesn't really care, would that be aiding and abetting? And then the court says, we're not going to answer that. We have no view on that. So not very helpful for our purposes. So let's look at our next one here. Now we have a landscaping company, Larry's. It's hired to plant some cannabis plants, okay, on the property of some local cannabis cultivators. The cultivators supply the plants, Larry's supplied the tools and the landscaping equipment and the people to do it. All right, so now we finally have a company that's touching cannabis, but it doesn't actually have title to it. It doesn't sell it. It's just touching the plants. Do we have enough under 841A here? Is Larry's manufacturing marijuana or cannabis here? Maybe. I don't think that one's a slam dunk. And so how about aiding and abetting? Do we have this? Do we have an affirmative act in furtherance of the offense of manufacturing marijuana with intent? Well, maybe. So planting the plants is definitely an affirmative act in furtherance of the offense of manufacturing marijuana. Larry's definitely knows what it's doing. Its employees presumably don't think they're planting begonias, right? They know they're planting cannabis plants. So if all we need for intent is knowledge, it looks like we've got aiding and abetting liability here. But what if we need more? What if we do need that purposeful participation in the act with an intent to bring the desired outcome? We might still have that here. Larry's probably wants the plants to be properly planted because it's a landscape company, right? So it's in the business of planting plants and making them grow. So Larry's may not care whether they're begonias or cannabis plants, but if it's planting plants, by goodness, it wants to make sure those plants are going to grow. Okay. Because of this, I think we're going to be more likely than not a marijuana business here. Okay. Though there are still some more facts that we would want to know. Does Larry's do a lot of cannabis planting? Does it have special techniques that it uses to plant these kinds of plants? How much revenue does it get from planting cannabis plants? And what is its policy if the plants don't take? Does it offer a refund? Does it offer a replacement and give you, hey, those plants didn't work here, have some more cannabis? That would be bad, right? Or does it just say, too bad, so sad, we're not very good, and sorry about that, don't hire us again. I think the fact that Larry's is touching the plants makes it more likely than not to be in trouble here. I've got two more. All right, now we're on to fertilizer. So Frida's Fertilizers, an LLP that sells fertilizer to a number of commercial growers. It sells to everybody, but it gets 65% of its revenues from sales to marijuana cultivators. And it knows that these customers are using the fertilizer to grow cannabis plants and to make marijuana from that. All right, this one's definitely tougher because all Frida's is doing is selling fertilizer. There's no agreement between Frida's and the marijuana growers. The sales aren't contingent upon the fact that it is selling for the purpose of growing marijuana or anything like that. It's just selling fertilizer. Frida's doesn't care who's using it and what plant those people are growing. All it's doing is trying to sell some fertilizer, and it presumably works just as well for corn or soybeans as it does for cannabis. All right, so we probably don't have that same kind of intent that we saw in the last one, because we don't have some driving intent to cultivate and distribute marijuana in particular. Right, the intent here is just to sell fertilizer. All right, so probably we're not going to have enough for aiding and abetting. But we have problems directly under this CSA. Section 843A6 says it's unlawful to possess material knowing that the material is going to be used to manufacture a controlled substance. Here, Frida's has fertilizer, a material, and it knows that the fertilizer is going to be used to help grow marijuana or grow cannabis, so used to manufacture the marijuana product there. We also have section 843A7 tells us it's unlawful to distribute material knowing that it's going to be used to manufacture a controlled substance. Same problem here. Frida's is definitely distributing its fertilizer out there for the purpose of selling to people who are going to be growing marijuana. So as a result, I think we have another marijuana business here. Last one. We've got Jovial Janitors, a commercial cleaning company. They clean a whole bunch of retail establishments in Alaska, including medical and retail marijuana dispensaries. They use all the same equipment for these dispensaries as they use for any other kind of business. And they don't solicit dispensaries. And my sound cut out, I think. Can you guys still hear me? You can't hear me anymore. Hold
Yes,
on
we
one
can
sec.
hear you. We hear you. We hear you.
Oh, you do now? Okay.
Yes.
Whoops. Okay. All right. We're back. Cool. All right. So we're cleaning things, including dispensaries. Okay. So here we don't have a CSA provision directly on point. Right. Ultimately, we're going to need to figure out whether Jovial intended to assist the dispensaries in violating the CSA or whether its business depends upon their violation. Okay, so we're going to look at some facts and circumstances here that might be relevant. Things like what percentage of revenues is Jovial going to get from the dispensaries? If it's getting 95% of its business, its revenues from the dispensaries, that looks pretty bad. If it's more like 15%, that looks better. Okay. Does it have any services that are specifically tailored to the marijuana industry? So I've already said we're going to assume that it doesn't, that it's cleaning them just the same way as it's going to clean every other kind of business. That would be better. But if it had some specially tailored services or special products or anything like that, that's a bad fact for them. Okay. Does it dedicate specific employees with specific expertise to the dispensaries, or do all the janitors just go wherever, right? The more dedicated we are to the dispensaries, the worse that is. And last on my list that we could probably think about some more is Jovial marketing its services specifically to marijuana dispensaries. So if Jovial is going and saying, we are the preeminent cleaner of marijuana dispensaries, that's bad, right, for them. But if they're just cleaning the same way they clean everywhere and they're not specifically targeting marijuana customers, that would be better for them. Ultimately, I think Jovial's fine. I think they're just cleaning. I don't think it's a big deal here. But the fact that we even have to ask the question is pretty scary when we think about all the potential people who could get swept up, all these innocent bystanders, like the electrician who's installing the grow lights, and the irrigation system company that's putting in the irrigation system, and the interior design company who's making the dispensaries look really cool and mellow. All these people could potentially get picked up. Which is scary if you're one of those people or somebody representing those people. So what does this leave us with? What do we know maybe about when we're in danger of becoming a marijuana business? Ultimately, it depends. Okay, that's the overarching answer. The easy case is going to be the situation in which we have someone who has a license to be in the marijuana industry or otherwise meets a very clear statutory definition. It's also pretty easy when there are direct violations under the Controlled Substances Act, like landlords, equipment suppliers, maybe investors, depending upon how you read that. Okay. We have a good chance of indirect liability through conspiracy and aiding and abetting. We'd like to know a little bit more about the intent that we need there. And for these indirect cases, there's not a bright line. All these facts and circumstances are going to matter. So with that in mind, here are some of the facts and circumstances courts, I think, might want to look at. And I'm borrowing here from some of the facts that they actually do look at. So in tax cases and figuring out what kind of business a taxpayer is in, or the bankruptcy courts when they're thinking about whether they can give bankruptcy relief to people involved in the marijuana industry. Right, so they might look at control, direct or indirect. Are you controlling an entity that is clearly engaged in the marijuana business? Where do you get your revenue from? The more that comes from the marijuana business, the more directly it's tied to the marijuana business, the worse for you. All right. How much capital are you investing in marijuana-related activity? Obviously, more is worse if you're trying to avoid becoming a marijuana business. How much of your assets are deployed in marijuana-related activity? How much physical space are you dedicating to that? And so that's particularly a tax kind of thing. If you're selling marijuana goods and non-marijuana goods, how much of your floor is dedicated to the marijuana goods? How are your employees spending their time? The more people who are dedicated to marijuana type stuff, the worse for you if you don't want to be a marijuana business. And are you looking for marijuana related customers? Are you marketing yourself as a marijuana related business, or are you doing something generally applicable and that happens to be used by some people engaged in the marijuana business? All right. Ultimately, I think the court in Malul really sums it up quite well here. we need to think about the full scope of what the CSA prohibits, because there are a lot of provisions in there that don't leap to mind when we're thinking about what's prohibited under the CSA. And unfortunately, a lot of people could get picked up for doing things that they wouldn't think of as being in the marijuana industry. These cases are very fact intensive. They're very specific to the cases. So we don't have a lot of guidance, clear guidance going forward. But altogether, I think that anyone who's tangentially related to the marijuana industry needs to think really long and hard about what risk they're potentially exposed to. So thanks very much. I look forward to your thoughts.
Well, that really did not sound like a presentation about a drug that had been either decriminalized or legalized, or so very enlightening. I could swear we voted in favor of of something like this in Massachusetts just a couple of years ago, but I see that we have a long way to go. Let me remind everyone before our last speaker that if you have any questions, you can please just use the Q&A box at the bottom of your screen. Last up, we're going to hear from Sam Keeman. Sam is going to comment on the three presentations. Sam is an expert in this space, obviously, and he's going to comment on the three presentations that we just heard. So Sam, I look forward to your thoughts.
Thanks so much, David. And my thanks also to Jay Wexler and all the other folks at BU who put this conference together. When I was talking to Jay when he first invited me, I said, well, I could speak about this, but you have that person who knows a lot more about that than I do, and you have this person who knows a lot more about that than I do. So, this is really part of what's so instructive about a conference like this is just how much things have changed. I've been doing marijuana law and policy work since 2010-ish, and at that time it was people who come from a criminal justice background who had clients in this area, was people who did constitutional law, who were worried about the federalism implications of difference between state and federal law, and was really a lot of policy types, true believers who were really active in trying to get law changed. We've come a long way since then, right? To be on a panel today with someone who does banking, someone who does tax, and someone who does corporate work, it shows us how both how mainstream it is, and Lauren talks about some of the problems with the mainstreaming of that, and that people maybe marijuana businesses now without knowing it. But one of the things that's really struck me in listening to these panels and then looking at the program over these 3 days is just the changing nature of what it means to do marijuana law. That really now anyone who is providing legal services to someone who's in the marijuana industry, or for the reasons Lauren talked about, might be in the marijuana industry, really needs to understand sort of the breadth and scope of what marijuana law reform has wrought on the legal profession. As I talk to people around my state, back when we went to cocktail parties, people would say, "Oh, you know about marijuana law? Great, I have questions." Right? That whether they were in commercial real estate, or whether they were in water law, or whether they were in employment, public benefits, there's very few areas of legal practice that aren't touched by marijuana law reform. So people who think that their practice is insulated because they don't do marijuana law for the reasons that everyone has talked about really are and do and need to be aware of these changes. So I think it's a really timely idea for a conference like this, and a really good opportunity to reflect on what's changed and what we know and what we don't know. So I've been on panels with Julie before, and every time I am, I learn a little bit more about banking law. The phrase legacy cash is one that I'm going to adopt and steal completely. The idea, marijuana businesses have always had this problem of having a bunch of money that smells bad. And it really does literally reek of marijuana. I've talked to, it's an old and bad joke, but money laundering takes on a new aspect when your bank says you can bring us money, but it can't smell like that. I have talked to many practitioners who will tell me, well, Febreze is really good for that, or I put it in the washing machine, or I put it in the dishwasher. So the trouble of marijuana businesses getting banking services go beyond the legal to some very specific and technical ideas. So I sort of have some thoughts and some questions about what each of these folks have said. Some of these are going to be questions that maybe we can start our discussion when I've gotten through some of these. So Julie, you really highlighted the problem of people not in the industry not being able to get banking services, and some of those are practical for them, right? They have to pay a lot of money to be able to write checks, as you said, which I think is a very accurate description of the extent of banking services that even people who can get banking can get. The sort of transaction costs for those folks are really high. But the other thing that I think is really important that you highlight is how broad the concern should be about the inability of marijuana businesses to bank, right? So you mentioned safety, right? That if this is a cash business, if people are getting paid in cash, if payday is Friday, and criminals know that, that's risky not just for the marijuana business, but for all the employees of the bank, for all the neighbors of marijuana businesses, which for reasons that Benjamin talked about, can be in low income and historically disadvantaged neighborhoods. It's sort of a self-fulfilling prophecy that when you make it a cash business, you make it a subject of crime, right? And you can be a big opponent of marijuana legalization and still recognize that if we're going to have state-regulated marijuana businesses, they should have access to banking services for the protection of everyone, right? Not just so that they don't have to pay high fees, boo-hoo. They have so much smelly cash that they don't know what to do with it. That may not resonate that much with people who are opposed to marijuana legalization, but the security and safety concerns that are associated with that, I think, really are a much more public concern. And beyond that, I think that when marijuana becomes a cash business, that puts pressure on regulators, right? So if the regulators are charged, as they are, with making sure that there's compliance with regulation and that there's full payment of tax, the kinds of paper trails that we get with banking really make that kind of regulatory compliance easier to confirm, make the payment of tax easier to verify. So there are lots of good public policies that are served by having banking services available to everyone in the industry. I think your hemp example is a really important and interesting one. I'm wondering how much of the refusal of the banking industry to bank hemp businesses is the fact that hemp and marijuana are both cannabis plants, right? And this concern that hemp is still a front for marijuana businesses. And by marijuana here, I mean sort of psychoactive cannabis, that people are planting 10 acres of hemp and 1 acre of cannabis in the middle of it, right? And we've seen situations of that happening. Are banks just so concerned that, well, you say it's hemp and maybe it's mostly hemp, but we just can't know? You talk about the sort of THC testing regime and the way that's dealt with in federal law. In a perfect world, and this is sort of how much of fortune telling can we get from hemp banking? Sort of in a perfect world where marijuana is, all forms of the cannabis plant are legal under federal law, how broadly do you think banking would be available for that industry? So, you say, well, not every bank does aviation businesses, or not every bank does alcohol or tobacco. You can imagine some other similar business. What do we think that model would look like? It looks like it's 10% of banks and the smaller percentages of S&Ls. What do we think that would look like in a purely legal regime? Is sort of a question that came to mind as I listened to your presentation. Benjamin, one of the only benefits I think of purely online conferences is that I can use Google more discreetly while someone is talking. I had to look up Pigouvian, which is a word I'm definitely going to also incorporate into my lexicon going forward. I think you raise these really important issues about what an appropriate marijuana tax would look like, and the question that you raise about, well, what should that balance be between state and federal? If there's only so much tax that this market can bear, who should get it, whether it should be at the state level or the federal level? To my mind, the federal government, as a non-regulator of marijuana, as someone who has chosen, as an entity that's chosen to prohibit it rather than pay and then take on any of the regulatory burden, has a pretty weak case that it should get that money, right? That is, they prohibited it and still think they should get the tax revenue from it, seems like having your cake and eating it too. And, I know a lot of people who do the hard work of regulation of marijuana at the state and local level. To me, their claim that, if there's only a certain amount that the market can bear, their claim that we should get that at least to pay our regulatory costs, right? To have our the folks that go in and do these inspections, the people that do the hard work of putting together the public hearings and the regulation writing that takes literally thousands of person hours. We should get that revenue here at the local level. I was thinking of the late Mark Kleiman, who was one of the first people that really thought carefully about this stuff, and he talked about how marijuana should be a product that's legal but discouraged. And I'm wondering how is it possible to be agnostic when trying to come up with the right level of taxation? That is, my quick research on Pigouvian tax, sort of told me that we it may be, and you talk about this. When we're coming up with the right amount, part of what we're trying to figure out is how much marijuana consumption do we want, right? And I think we've seen, particularly with cigarette taxes and particularly with cigarette taxes and youth smoking, that raising the cost of cigarettes, while it's a regressive tax, has had real beneficial impact on cigarette consumption, and particularly on cigarette consumption by young people, right? So when we're trying to figure out, well, what should taxes on marijuana be and who should be imposing them, I think we have to decide, well, is this a substance that's just a choice that adults should get to make? Or do we say, as Kleiman did, well, the less of it we have, the better that would be. In closing, with regard to your talk, I'm really glad you mentioned our mutual friend Pat Oglesby and the work that he's doing on this, and particularly the things that he says about 280E. He is, you said, well, not that many people are saying this, but Pat is, jumping up and down and saying this every day. The best thing about 280E, for all of its bizarre incentives and injustice, is it discourages marijuana advertising, right? And marketing, advertising, targeting to vulnerable groups. When businesses can write off that activity, they have an incentive to do it. And one of the really, if we're looking forward in the future to legalization at the federal level, one of the hard questions will be the capacity of the federal government to regulate or prohibit, as some states, including my own, have done, marijuana advertising. It can be done through tax policy in a way it can't be done directly, right? That is, it may be that a blanket ban on certain kinds of advertising is prohibited, but keeping that part of 280E that denies deductions for advertising could have the effect of suppressing that that conduct without some of the constitutional problems. So I think that's really going to be an important point going forward. And then, Lauren, I really loved your presentation as well. So many people in this industry or ones near it talk about the distinction between licensed businesses and ancillary businesses, right? So there are the businesses that have that, as you mentioned, that license from the state to manufacture, distribute, produce marijuana products. And then there's everybody else, right? And for lots of investing purposes, a lot of investors say, well, of course, we're not plant touching, or we don't invest in licensed businesses, just the picks and shovels is a phrase one hears a lot, right? And the analogy is to the gold rush, where the people that, Levi Strauss made the money not by going into the hills and panning for gold, but for selling jeans to people who would, right? And so that's been this sort of attractive and seemingly safe alternative to investing in a licensed or plant touching business. And I think for the reasons that you talk about, that is an overly broad and in fact quite dangerous, or at least potentially dangerous, false distinction, right? That for the reasons you talk about, people who might not think of themselves as in the marijuana business may, particularly in the way you're talking about it, find themselves there. And in fact, I think you may have shocked some people by the how far out that liability goes. I think it goes much farther, right? I mean, one big area that you didn't talk about that, you know, is near and dear to many of our hearts is accountants and lawyers and other professionals, right? Is it legal? Is a person aiding and abetting or joining a criminal conspiracy? You know, you mentioned the Malal case from the District of Colorado, from the bankruptcy court. What about the lawyer for the parties there? They are the lawyer for marijuana business. They are providing services in the same way that, you know, you mentioned the landscaper and the janitorial service. Lawyers and accountants are doing a lot of work for a lot of businesses. They may be charging differential prices for that. They may offer themselves as a full service marijuana law firm. I've certainly seen a number of firms that use that terminology. That's you know, a big red flag in your sort of taxonomy of how you become a marijuana business. You know, they, you know, and to Julie's point, you know, I know a bunch of banks charge differential pricing to marijuana businesses, right? Are they, if they say, you know, we're happy to bank this industry, we charge more for marijuana clients, but, you know, that's the price of doing business. That sure looks like benefiting from and joining a criminal conspiracy. It sure looks like aiding and abetting. So, you know, there's really very few limits on how far this can go. One, you know, people in that I know that practice this area, and you know, you were only talking about the criminal liability. We also need to think about the professional rules of conduct, right? The model rules that say you can't knowingly facilitate criminal conduct. That's everything that every lawyer does for every marijuana business, is facilitating criminal conduct, and they all know that they're doing it. I've written that I don't think that's unethical conduct, but a clear and literal reading of the model rules would seem to bring that in. You know, what about the regional water authority, right? That from whom farmers buy their water, you know, and when you're you know, Colorado Green Medicine, and you're buying a huge amount of water for your outdoor marijuana grow, the regional water authority knows who they're selling that to. Are they joining a criminal conspiracy? You know, all the public utilities that supply these businesses, they might be in the same situation. The state tax authority, how it is able to take this money that the banks Julie talks about can't, right? The same, you know, Wells Fargo armored car that won't come to a marijuana business to take the money. I know that it goes to the State Department of Revenue, and it takes that same foul smelling money and puts it into the state's account. How does Wells Fargo avoid liability for that? So, you know, I think it's actually good news that there's no logical stopping point for this, right? There's sort of this safety in numbers piece that can't come for all of us, right? I'm a professor who makes lawyers who represent marijuana businesses. So, you know, the final exam question I've asked is, am I in a criminal conspiracy with all of you to violate the Controlled Substances Act? You know, there is some good news in that's sort of this reductio ad absurdum, right? That if the power provider and the water resources and Home Depot, and if everybody's in the conspiracy, then nobody's in the conspiracy. So I learned a lot today. I really appreciate you guys letting me participate and bounce some of these ideas off. And with that, I'll hand it back to David. We can continue our discussion.
Well, Sam, it turns out that your exam question was also one of the questions that popped up in the Q&A. So I think we can call that one answered. I did want to give you each of you, since Sam made comments about each of your presentations, I think it would be great to get some of your responses from each of Julie, Benjamin, and Lauren. So Julie?
So first of all, Sam is absolutely right that I think that even if you're not enthusiastic about marijuana as a whole, that you can easily come to the conclusion that marijuana banking is something that we ought to have, in part because it reduces opportunities for criminals, but also in part because it makes it easier to regulate and tax. You know, Benjamin was talking about setting the optimal tax. Well, if all of this is done in cash, the likelihood that you can collect your optimal tax goes way, way down. And so I think if we're still sort of squeamish about the idea of about how much can we really project from the legalization of hemp onto what we think might happen with marijuana. I think one thing that suggests to me that it might be somewhat analogous is I suspect, and I'm not a political scientist, so this is just my own reading of the tea leaves, and Sam's probably better at projecting what I am in this space anyway, but I suspect that if marijuana becomes legal or decriminalized at the federal level, what we're likely to see is a licensing regime, right? Whether that's done by the state or by the federal government. And so that suggests that at least in the cannabis space, what we're likely to have is what we have in the hemp space now, right? We have some conduct that's okay because it's permitted, but other conduct that remains criminal because it's not permitted. And I think that for banks, making sure that your customer is on the right side of that line is always going to be costly. So what might we expect to see? Well, for banking regulators, there is a big, long, wide list of high-risk customers or high-risk businesses that they expect banks to do extra due diligence that makes those banking relationships more costly. And some of them are what I would consider like a little bit high risk, and then others are what I would consider sort of very high risk. And I think banks approach it the same way. So you might not realize, but attorneys and accountants and other professionals are typically considered high risk banking relationships because it's very hard for banks to figure out that you are making your money by actually doing legal services and not by doing something illegal. And so they're going to charge you more for that risk and for the due diligence that they'll do to make sure that you're actually a lawyer and that you're providing legitimate services and that you're not just laundering money through your law practice. But that's, most lawyers who go out to try to find a banking relationship don't have a terrible time. They might pay a little bit more, maybe they don't even realize they are, but they all wind up getting banking services. At the other end of the spectrum, you have very high risk businesses like diamond dealers and casinos and those pawnbrokers, those sort of folks. And they're higher risk because not only do they have this risk of money laundering, they also have this risk that we think could be somewhat like the marijuana risk, that they operate very close to the line between what is illegal and what is criminal. Right, so those folks have fewer banking relationship opportunities and it is more costly. Now, there are other things that are kind of in the middle, and then I guess there are other things that are also high risk, like mining, in part because of the reputation risk that is assigned with it. So I think that we're seeing the reputational penalty for marijuana reduce just as people become more accepting of it. So I don't think that that's going to put it way far to the left, but I think that we're still going to have this space where some conduct's legal because it's permitted and some that's not. And so I don't think every bank is going to be in this space, but do I think that there'll only be a handful or there'll only be the 10% or less that we have now? No, I think you could easily see double or triple the number of banks in the space if you had a robust regulatory scheme. And again, I think regulatory schemes help. So in states where the state tracks and makes it clear who has access to the marijuana plant from bud to being sold, like those states have easier times getting banking relationships than states where it's not as clear who has a legal right to be in possession of marijuana.
Benjamin.
Great. I'll try and be really brief because I could talk all night about these things. So just a few responses to the very interesting and helpful things that Sam said. The first has to do with this split between the federal and the state level. And obviously the considerations in that split, it makes a big difference if we're talking about the split right now when you have federal level illegality, or if we're projecting future to a world where the federal government has decided to legalize at the federal level, and then they're either keeping 280E, I mean, they couldn't keep 280 because it doesn't apply once they've legalized it at the federal level, but they could move it into a 280E-like tax, or they could create an excise tax regime, one or the other. It's much more likely that once we get to that stage, they will move into an excise tax regime. You're exactly right that the idea of the federal government taking its cut when in effect what's being created is a surplus by state level investing in a legal market and investment. There's something infuriating about that. Like, why should the federal government be extracting this cut Maybe it doesn't go so far as sometimes people think it does, because all illegal activity that is profit making is taxable, and the federal government should be taxing all of that. It's just, it's so burdensome to tax it that they end up not taxing it very effectively. People who are involved in criminal activities are good at evading taxes as well as engaging in criminal activities, but it's all theoretically taxable. So that's the kind of the federal to state split. Once it is legal at the federal level, there might be pretty good arguments for the federal government taking a cut, and some of them might have to do with the fact that there might be spillover harms from state legal states to states that choose to continue to have cannabis illegal. So, and the federal government is a location where it can equalize those, where it can invest in the spillover harms or mitigating those spillover harms in the ways that states can. So there might be reasons for that. I'll just say one more. The second point is just about Pigouvian taxes. The main point I want to make about Pigouvian taxes is all of the arguments we could have kind of about what is a good Pigouvian tax coming from this idea that should it be legal but discouraged. The Pigouvian tax is about discouraging it, but that's all of those very contentious possible arguments about what's an externality and what's an internality and what are the public health causes by marijuana, and are there any public health causes of marijuana once you take away, even for 17-year-olds, are there any, all of those arguments, those actually relate to a very small set of the important questions, because that's only when this surplus drops prices so low that that's the main thing you're worried about. What we really have to be worried about is thinking about how to sop up some of that surplus and not sopping up too much of it, and really thinking what should we be spending this money on, and how can we get sort of the most of it consistent with other issues of fairness and justice, like you mentioned, the regressivity of a cannabis tax. That's a legitimate concern, but really fighting over what the nature of it as a Pigouvian tax. What should we be discouraging, in the world in which the most obvious substitute for almost every user is not reduced consumption, it's consumption through an illegal market, as long as that illegal market still exists and is robust. So I'll leave it at that. Thanks.
Lauren?
Hi, also, Sam, you're right. I very conspicuously left out lawyers and accountants, and only really in part because people have written about lawyers and the ethical issues there. Though I think you're right that it's not just an ethical issue; it's also a civil and criminal liability issue too. But they seem to be almost too easy a case, so I figured it was scarier to talk about fertilizer and cleaning services instead. But it's absolutely part of the whole web of everybody who could be in trouble. And I think your point is really well taken, that the group of people who could be in trouble is so large that probably nobody is going to get in trouble. I mean, it's like catching everybody who's speeding on the highway. But then again, it's not that police officers just say, we're not going to catch anybody. So they do end up catching some of the speeders. So maybe they catch some of the more egregious ones. But in all likelihood, in all practical reality, I think what's going to happen is these issues that I'm bringing up are going to be more issues in litigation, when in the bankruptcy kind of situations, and in other getting out of contract situations. I think there are going to be useful legal arguments to say, well, that contract wasn't valid to begin with, or you can't have bankruptcy relief anyway. And that's one of the very, very troubling things from if you want to support legalization of marijuana. I think looking at the bankruptcy cases is very troubling because of the ways that they are willing to find some of these ancillary businesses to have unclean hands, to say they have engaged in illegal conduct. If we think about bankruptcy courts as usually trying to work things out for the debtor as well as possible, the fact that some of the courts like the Malone court are saying, nope, you guys are all engaged in illegal stuff, so no relief for you, is a little bit worrisome. But I do think in practical reality, probably not everybody is going to get arrested or face massive civil and criminal liability, because there's already pretty clearly a policy choice not to go after everybody. But I like writing about the doomsday thing. So everybody could be in trouble. You just probably won't be.
So I think we'll take the last 4 minutes to put Sam on the spot and anybody else who wishes to dive in, and just ask Sam, what do you expect from an incoming Biden administration, and for that matter, at the state level as well? what kind of changes might we see in this space in the next few years?
Great. Yeah. For forecasting marijuana law has been a fool's errand. So let me embark on it for at least a few minutes. So look, every time marijuana initiatives are run during a presidential year, they do really well, right? And we saw that again this time around. The 5 places where marijuana legalization was on the ballot. It passed in some places, that if you asked me 8 years ago, when will South Dakota legalize marijuana? I'd say, well, just the day before Utah does, I think. So we're really getting far afield from the Washingtons and Oregons and Colorados and Californias and getting into, deep red states. And obviously, the more states that adopt marijuana law reform and that move away from their own state prohibitions, the more pressure that puts on their representatives in Washington. And, very few people are single issue voters on the question of marijuana law reform, but, having a blanket prohibition in a world where now a supermajority of the American people live in states where marijuana is legal for some purposes, it creates a continuing and sort of increasing pressure on those states. On the federal government to change that law. What form that will take? Well, we've sort of seen an increasing number of bills, and Julie mentioned a number of them in her presentation. The sort of alphabet soup from SAFE to MORE to states, and some of them are really just a decriminalization. Some of them are the federal regulation that Benjamin talked about, and some of them are sort of nibbling at the borders, right? Fixing banking, fixing tax. What sort of cooperation will President-elect Biden get from Mitch McConnell in the Senate? Will the Democrats, with their slim majority in the House, continue to push on that? I think those things are really difficult to anticipate, but the pressure for it is only increasing as the number of states push that are changing their own laws just increases every 2 or 4 years now. So I'm curious what the other panelists think as well.
Any last thoughts in the final minute on that? No wild speculations? All right, everyone. Well, that was a really terrific panel. I really want to thank all of our panelists for the excellent presentations. That's going to conclude not just this panel, but I believe, unless Megan may jump in to yell at me, I believe that is the last panel of the day. The next panel in the conference restarts tomorrow morning, 9:30 a.m. Eastern, with a panel on legalization of marijuana on a national level. So we'll end it there. Thank you again for coming. Thanks to the panelists, and we'll see you tomorrow.